to Crime in Court. My name is Heather, and this is episode 55 of the Canton Cover-Up Commonwealth versus Karen Reed, and we are going to be talking about the Commonwealth's opposition to Reed's motion to dismiss. So the Commonwealth responded today, and we have the response. So we're going to read through that. And I was going to say something else, but I can't remember now. So let's begin. Please hit that like button before I get started. It helps the algorithm and it helps push the video out to more individuals and it helps YouTube know what you like. So let's get started. This is the Commonwealth's opposition to the defendant's post-trial motion to dismiss. Sorry, I'm not used to this uh, particular program. All right, so now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree homicide and leaving the scene after causing someone's life to be lost, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. That's their reasonings. That it's hearsay, conjecture, and legally inappropriate reliance as to the substance of the jury deliberations, which I don't know. Oh, that's better. Okay. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. I don't know about that. I don't think so. They were not. And we watched it. She rushed them out of there. She rushed the jury out of there before anything could be said. She did not allow for any kind of comments. Um, all right, so this is arguing that contrary to the defendant's claims, during deliberations, throughout the deliberations, the defendant was given full opportunity to be heard. No, the jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. Did she, though? Because it was like bam and boom out the door. She didn't ask them a single question. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. I don't know. At least four jurors have come forward to say that they were unanimous in counts 1 and 3. Count 1 was double homicide second degree, and count 3 was leaving the scene of injury and or loss of life. So those two she was acquitted on, according to four jurors that have come forward to the defense. And because they had a feeling that something wasn't right with the Commonwealth, and they probably weren't going to go to the Commonwealth with it because they're the ones that they were suspicious of. So, yeah, and then now there's also rumors of a fifth juror who has come forward, and that's interesting too. And that fifth juror might have been the foreman who might have thought that she was actually guilty of manslaughter. Manslaughter was the second charge that they were hung up on. And a lot of people are like, how could they be split? Okay, it all has to do with intent. If anybody's questioning why could they acquit her on 1 and 3 and not 2, it has to do with intent. And knowingly hit him and knowingly left a scene as to where someone was injured or they lost their life. So if she didn't know that she hit him, then she didn't drive away from someone in need of help. Does that make sense? So it totally makes sense that they go together. The parts that they were hung up on was part 2, which was all the manslaughter and the like lesser charges that were in there. And it was very confusing and I don't understand it myself, but that's what they were hung up on. And manslaughter just means it could be unintentional. It was reckless behavior, da 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 da. But The way that it was worded, it couldn't just be like negligent, reckless. It had to be, she still hit him negligently, whatever. So you still would have had to believe that she hit him with her car. So, anyways, that's little clarification if anybody needed that. All right, so they said that they were at an impasse. The court carefully considered all the alternatives. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit. Well, we know that that's not true because we've got four, at least four, probably five people that have come forward to say the same thing on those charges. All right, so on June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree homicide in violation of this. Okay, manslaughter. We just went through all this and leaving the scene. Okay. On April 16th, 2024, a 10-week jury trial commenced. Beverly Canoni. The jury began their deliberations on June 25th. In addition to the three indictments, the jury was instructed to consider two lesser included offenses to manslaughter while operating under the influence. One, see, this program is like, I don't like it. I wish I had a PDF. Sorry. Gotta slip and slide around here. All right, so involuntary manslaughter. Two, motor vehicle homicide under driving under the influence or operating under the influence, liquor, and negligence in violation of that statute. So it was either involuntary manslaughter or motor vehicle homicide with negligence because of her drinking. But you still have to believe that she did it, that she hit him with her car for this, which I can't believe that there were that many people that were willing to put her away for manslaughter, which is still like 25 years, which is crazy. All right, so it's crazy that the jury's just like, yeah, well, whatever, let's put her away for manslaughter. It's not good to come to some kind of compromise as a jury. Don't compromise your beliefs. All right, so the defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's a consent to the mistrial. No, I'm sorry. There was no the defense has it right. She rushed them out. There was no opportunity to ask for them to be polled. Nothing. Nothing. I fully believe that the jury was rushed out of there on purpose. I really think Bev is corrupt. Tell me otherwise. Prove it. Prove that she's not. All right, so beginning on Friday, June 28th, at approximately 12:15 p.m., the jury sent a note stating, quote, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." At that time, the court requested argument from the Commonwealth and defendant as to whether the jury had engaged in due and thorough deliberations. So that was Friday, June 28th in the afternoon before lunch. The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. On the contrary, Attorney Yannetti argued, "We believe that there has been sufficient time," and advocated for the jury to be declared deadlocked and provided the Tui Rodriguez instruction. Attorney Yannetti stated, "The word exhaustive is the word that I think is operative here." Sorry. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report they were not allowed to get because it didn't exist. And I think the message has been received that the evidence is closed and they won't be getting anything more. Yes, because Bev had her curt response of, "You have everything you need to make a verdict." That was all she, when they, would you want to ask any more questions of that judge? No. They saw how she talked to Alan Jackson and Yannetti. They weren't stupid, they were watching. All right, so they've been working essentially nonstop over the last 3, 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So, our position is the jury should be read the Tui Rodriguez model instruction and go from there. So, that was the quote from Yannetti. Instructions. All right, nothing. All right, so the court ruled that given the length of the trial, number of exhibits, and complex issues in the case, there had not been due and thorough deliberations and instructed the jury to continue deliberating. On Monday, July 1st, at approximately 10:45 a.m., the jury sent another note to the court stating, "Judge Canoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind." So it's okay. Um, this is just worded so oddly, and it makes you just like question the way, why did they word it like this? All right, so that divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Following receipt of that note, the court again inquired of the Commonwealth and defendant as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and number of witnesses, the jury had yet to engage in thorough deliberations. Attorney Yannetti again sought a Tui Rodriguez instruction stating that the jury has come back twice, indicating essentially that they're hopelessly deadlocked. They said they've been over all the evidence. As at this time, they say they have fundamental disagreements about what the evidence means. It's a matter of opinion, it's not a matter of lack of understanding. The court found that at this point the jury had engaged in due and thorough deliberations, noting that this has been an extraordinary jury. The court indicated it had never seen a note like this reporting to be at an impasse. And what does that mean? And she picked the foreman, remember? She picked the foreman before she even selected the alternates. And the foreman supposedly is the one that is crafting these oddly worded notes, who Judge Bev has praised as, or well, I don't know if it's a praise, but she said she's never seen a note like this. All right, so at approximately 11 a.m., somebody needs to check her relationship with that juror, just saying. All right, so approximately 11 a.m. on July 1st, 2024, the jury was advised of the full Tui Rodriguez instruction, including that it was the jury's duty to decide this case if you can do so conscientiously, and that there is no reason to believe another jury would be more competent to decide this case. Okay, so this is just a recap of what's been going on since or throughout deliberations, but it really doesn't matter because the defendant, so all these things that he's saying, like, well, the defense had a chance to talk here. That's fine. And they might have been pushing for a mistrial, but there was no indication anywhere in any of those notes that the jury had come to a consensus on any of the counts. If they had said that, I'm sure the defense would have said, hey, let's take a poll and find out what counts they're deadlocked on and which ones they've decided so we can tell if she's acquitted on anything or not. You know what I'm saying? Like, why is this so difficult to understand that it's not the same thing? Lolly's saying, well, they had a chance. Well, no, not really, because they didn't have any clue that they were going to be deadlocked on only one of them. as opposed to all three of them, because the jury didn't give any indication. They didn't know they were supposed to or that they could. And they were told in their jury instructions, which were very confusing, not to fill anything out until they were all unanimous. Oh, and to not tell Judge Bev anything or anyone what their votes were. So I blame Judge Bev and the jury instructions, whoever wrote them or provided that unclear language. And I sort of blame the jury slightly because they didn't inform anyone. Like, what the hell? And yeah, anyways, it's frustrating that they didn't inform anybody. All right, so on July 1st, the jury sent the final note. We read that. Um, where was I? Oh, no, I didn't read this one yet. All right, so at 2:30, the jury sent a final note to the court stating, despite our rigorous efforts, we continue to find ourselves at an impasse. So this is that Monday after that Friday. So they've been prolonging it, but not one of their notes said anything about having made a decision on any of the counts. Because this is their final note. Despite our rigorous efforts, we continue to find ourselves at an impasse. I wonder if this, hold on, I just had a thought. I'm sorry, I'll read it in a second. I just had a thought. If this is Bev's choice, before she even picked the alternate, she picked this four-person. This four-person's writing the notes. I wonder if the four-person was ever instructed how to write the notes to make it clear that there's a mistrial, and also to not make it clear that any of the counts were decided on. Ever think of that? That the four-person is in this, the four-person is the reason he's to blame is because he's part of it. He said he was gonna, well, according to Turtle Boy's tweets today, he said that he was going to vote guilty on manslaughter, this fourth juror. I don't know. I don't have confirmation, but that is the rumor out there in the Twitterverse now. All right, so um, here's their note, the final note. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charge. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. So I wonder if it had somebody who was against drunk driving or something. Maybe they were like hung up on that because they're against drunk drivers. Maybe they're biased and they have, um, or it could be a McAlbert plant. I don't know, but for whatever reason, we're sitting here talking about this, and Karen Reed should have been acquitted a long time ago, and now we're talking about why the Commonwealth doesn't want the jury polled. It's just crazy to me that we're even here. All right, so to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Following receipt of that note, the court discharged the jury very abruptly, I might add, and declared a mistrial. She was like, okay, that's it, bye. It was really like that fast. We watched it. I don't want to watch it again, but it was super fast. And then I'm sure the defense was like, what? Like everybody that was watching it was like, what? Like what? She didn't like it just felt odd and weird, like off, like something was off with it. And even the jurors were saying in the juror four, juror D that came out that said, they were talking about it on the bus and why nobody asked them about the other counts and that they came up with an acquittal for those. So Even the jurors left there feeling, they said they felt rushed. They were rushed out of there and onto a bus, and the bus ride, they were all talking about like, well, that was weird, wasn't it? And why did we get rushed out of there? And why didn't we get to tell them about the other counts that we acquitted on? And I don't know. I think that their final note was, personally, I think that they were expecting more instruction from the judge at that point, and maybe they weren't expecting to be just rushed off. I don't know. All right, so the representations made in counsel's affidavits have no legal bearing on the mistrial. Bullshit. I don't agree with that. As the jury did not reach any verdicts, partial or otherwise. We don't know that, and that's why we should ask them. You can't say definitively that they didn't. All right. This says verdicts must be reported in open court. Well, they weren't reported because they weren't given an opportunity to. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict, given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. Okay, that's fine and all. We can do that still. They weren't asked, and they need to be asked. They need to be polled. So Lolly can suck it. It is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. Whatever that means. All right, so the hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts, according to this Bluford versus Arkansas, which we've, uh, I think the defense was quoting in their motion to dismiss. All right, so in Bluford, the jury sent a note to the court indicating they were hopelessly deadlocked, and the court asked the foreperson to disclose the jury's votes on the three charges: first degree homicide, manslaughter, and negligent manslaughter, or uh, blah, blah, negligent homicide, sorry. The foreperson reported the jury unanimously agreed the defendant was not guilty of homicide, but were deadlocked on manslaughter and had not voted on negligent homicide. The court gave the jury an Allen charge that emphasized the importance of reaching a verdict. After an hour and a half hour, the jury reported that they had not reached a verdict and a mistrial was declared. The United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of homicide as a foreperson's report was not final verdict because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on that charge. And the difference here is the jury here didn't go back to deliberate, and they all said they were unanimous on it. Well, according to these four, but they say that the other 12 are going to say the same thing. So we'll see. I guarantee that if the defense is given the permission from Judge Bev, which I doubt she will, but we'll see. If they are given the permission to go talk to the jurors, they're going to talk to all 12 and get affidavits from all of them stating that same thing, if they can. All right, so the United States Supreme Court emphasized that when jurors engage in discussions about the circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. The very object of the jury system, after all, is to secure unanimity by a comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. Alrighty. It must be recognized as a particular matter that jury votes on included offenses may be a result of temporary compromise in an effort to reach unanimity. struggle with that word. Said it right perfectly the first time. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. So he's trying to say like an oral confirmation of it in the jury deliberation room is different than putting it on the jury form. The jury's notes were unambiguous that the jurors were deeply divided, but fundamental differences in our opinions and state of mind that resulted in a starkly divided jury as to the charges. The jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where consensus is unattainable. The jury's notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident that the jury was unable to agree on any charges due to their sincere adherence to their individual principles and moral convictions. Contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial. She didn't know. She didn't know that there was this acquittal of two of the charges when, I mean, she's not saying call a hung jury for any charges I might be acquitted on. That's not what she's calling for. She didn't know because the jury didn't say anything and the court didn't tell them or ask the questions to find out. All right, anyways. So they're saying she consented to the mistrial as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. I don't agree with that because I don't agree that she was remaining silent on it because she didn't know. Deliberation, what? Okay. That was in the middle of a sentence. Did I miss the beginning here? I don't want to read that. Let's get out. Sorry for all the flipping. It's annoying. Okay. So during her full opportunities to be heard on June 28th, 2024 and July 1st, 2024, her full opportunities, like she had much of an opportunity to say, hey, no mistrial, let's check the counts when, I don't know. I don't think they had any opportunity and there was no indication that she would need to ask the question. All right. So at no time did any of the defendant's three counsels request inquiry as to what charge or charges the jury was deadlocked on. Rather, the defendant was quick to request a Tui Rodriguez instruction at first opportunity, indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Attorney Yannetti, the jury was hopelessly deadlocked, had exhausted all manner of compromise, and was engaged in fundamental disagreements of what the evidence means. It's a matter of opinion, it's not a matter of understanding. Alrighty. Um, okay, I'm not going to read all of that either. Good. We can get through it. Where did all these stupid parentheses end? Okay. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussions about choosing a status date for scheduling a retrial. But we watched it. She sent the jury out real quick. They sat there, watched them leave, and then she's like, "Okay, so let's schedule a status. When are you guys free?" Like she didn't give them any opportunity to talk about anything. And again, they didn't know to ask because there was no indication. There's no indication. How do you know to ask that question when the jury is writing the notes to make it seem like they're deadlocked on all the counts? Why would they do that? I wonder, Mr. Foreman. I suspect you being shady. All right, so the mistrial was also supported by a manifest necessity jury deadlock. See Commonwealth versus Bryan. The trial judge is best situated to determine whether the ends of substantial justice cannot be obtained without continuing the trial. In declaring a mistrial, premised upon the trial judge's beliefs that the jury is unable to reach a verdict, that decision is treated with great deference because otherwise there would be danger that the judge would employ coercive means to break the apparent deadlock. Okay. These parentheses, geez. All right, so the court engaged in considerable efforts and sent the jury back to deliberate 2 times, following notes that they were at an impasse, and in addition to finding that the jury had engaged in due and thorough deliberations and providing the Tui Rodriguez instruction at the request of the defendant and to her satisfaction. During deliberations, the court amended the verdict slips to depict clearly the lesser included offenses and provided the jury a supplemental instruction on how to consider lesser included offenses. But was it ever clear? I think those forms were so confusing. I don't think they knew what to do for those. Honestly, I don't. Um, I mean, it just seemed confusing, that form. And I don't even know if they, because I don't think we ever saw the final form, so I don't know what the final version looked like either. What changes did they make for the defense? What, if any, changes did they make for the defense? And by the way, guys, sorry for the darkness. My light is down because I had a migraine this morning, and I just the light in my eyes, I don't want it coming back. So, anyways, all right. So the defendant's claim that the judge should have inquired of the jury holds no merit, as nothing in our case law required the judge to make either inquiry whether there was reasonable probability of any unanimous verdicts or if the jury would consent to further deliberations as a matter of course, and the circumstances before the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. In other words, the jury was deadlocked. The note did not suggest, for example, that the jury were merely having trouble making a decision or needed further instructions from the judge. Given the 4 days of deliberations, the jury's indication that they had clearly reviewed all the evidence and that their divergent opinions were premised upon deeply held moral convictions, the court was left with no reasonable alternative other than to declare a mistrial. Further consultation with counsel would not have produced any fruitful alternatives, nor was there a reasonable probability the jury would have consented to deliberate further, particularly when the jury wrote to continue to deliberate would be futile and only serve to force us to compromise those deeply held beliefs. Moreover, whether counsel initiates contact with a discharged juror by first sending notice to the opposing party with the substance of the proposed communication, or if the juror initiates contact with counsel, as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects. Here he's citing some BS uh, rules of professional conduct. Permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberations. Yeah, or a juror's bias towards a defendant. I think any of that going towards deliberations, yes, this is regarding deliberations, so I think it's relevant. All right, so C, Commonwealth, whatever. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been an issue. Whatever. Come on. Sorry, I don't like this program. Where did our many things? Okay, here. Rather, sorry. Rather, What the defendant's motion is entirely premised upon and what is expressly prohibited inquiry is that the jury's deliberative process and the substance of the jury's deliberation. So that is expressly prohibited. However, they're expressing concern about the verdict, not necessary. But this is, I mean, you're just going to overlook the fact that you might recharge a woman who's been acquitted. That's basically what this comes down to. They don't care. They will recharge a woman who's been acquitted of these charges. It's ridiculous. The secrecy of jury deliberations has served as a bedrock of our judicial system, and inquiry into the jury deliberative processes would intrude improperly into the jury's function. They're not asking about the processes, they're asking, did you come to a verdict? That's not, that's really, I mean, I love how the Commonwealth just twists everything to fit their narrative, and it drives me insane. Common law principle that it is essential to the freedom of independence of jury deliberations that their discussions in the jury room should be kept secret and inviolable, inviolable, inviolable. That's, you know what I mean. Was not and arguably could not be overruled by the 2015 adoption of whatever this is. So it can't be violated. It's got to be kept secret. Shush. In the proper It is proper for counsel to inquire with jurors or through intermediaries. So you can use an intermediary, which is why they were doing so in some of the cases. In other cases, the jurors came directly to Alan Jackson. Um, All right, so where were we? So they can the thought it is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought processes of the jury, the reasons for their decision, or the substance of their deliberations. It's not though. I mean, they're not asking that. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of the jury deliberations. You're not asking the substance of their deliberations other than did you come to a verdict? Is that true that you came to a verdict? Yes? Okay, great. Moving on to the next juror. It's really not that improper to ask this. I hate all these stupid things. All right, so the Supreme Judicial Court has instructed that whenever a judge asks individual jurors about the possibility of extraneous influences on jury deliberations, whether of jurors who are still sitting as such or jurors who have been discharged, the purpose of the individual voir dire is not to delve into the jury deliberations. There should not be an inquiry into a juror's individual or the jury's collective thought processes. Again, all you're doing, all the judge needs to do is ask, bring them in one by one. Did you come to a unanimous verdict on count one? Yes or no? Did you come to a unanimous verdict on count three? Yes or no? Okay, next question or next juror. And you pull them, you find out, and then even though they didn't write it down, it should still be valid if all 12 of them say on the stand that, yes, we acquitted her. I don't know why this is so complicated. Likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Judicial Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in, sorry about that, people are home and dogs are excited and going crazy, so they're being noisy. I had to kick them out of the room. All right, so likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies. Um, like I said, you just need to call them in, ask them, did you come to a unanimous verdict? Yes or no? Maybe even ask the foreperson, why didn't you write it down? Okay, why wasn't it written down? And then, did you know you could write it down? And, did you know you could have a split verdict? And I don't think a lot of people knew that. I think a lot of people were questioning whether they had to be unanimous on all charges or what. And I don't know. I think that they also had to be sure on all of their charges before they filled the verdict form out, which is another thing that was confusing in the jury instructions. So, um, but also another thing I wanted to point out is that this is not like months and months later that the jurors are saying they want to come forward and change their verdict or give a verdict. This is like the next couple of days after the trial ends. They're in getting in touch with the defense attorneys because they feel like the Commonwealth is screwing Karen Reed out of her constitutional rights. So, I mean, what does that say to you? That people are coming forward because of that fact. And the whole premise of the defense was that, the Commonwealth is after her, and the Commonwealth, prosecution, law enforcement, the McAlberts, all of them against her. And here we are now. Judge Bev, I think, is against her as well. All right. Moreover, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. In many instances, asking a deadlocked jury about partial verdicts would constitute attempting to extract from the jury something that does not exist. Asking a jury to report where they stand on the offense as charged invites a report that may be based on only preliminary tentative deliberation, if any, on that level of offense or hasty resumption of deliberations concerning that level of offense in an effort to satisfy the judge's apparent desire for a decision. Such inquiries of the jury may succeed in extracting a partial verdict, but we would not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. But they're done deliberating. They already made that choice, supposedly. I mean, this is the thing. Just ask them. Just find out. I don't feel like even reading the rest of that because it's dumb and it doesn't really say a a whole bunch of, it's a bunch of BS is what it is. All right, for the ongoing reasons and the defendant's motion should be denied as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharged jury. The defendant consented to the mistrial, and the court properly declared a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the three indictments and any appropriate lesser included offenses. This is coming, straight from Michael Morrissey. Or no, well, respectfully submitted for the Commonwealth, Michael Morrissey, Adam Lally, and Laura McLaughlin. Usually Morrissey doesn't sign, so I'm thinking it's coming directly from Morrissey, which is interesting because he is under a whole lot of scrutiny for his um, comments that he put out in the public a while ago and saying that he doesn't know the McAlberts and he has no close relationships and that Colin Albert was not in the house that night. And beg to differ, sir. Several people put him in that house that night. Um, So yeah, Michael Morrissey. What's up with that? Anyways, what do you guys think of this? I think it's a BS motion. I think that I think it's very appealable if Judge Canoni were to deny an inquest of the jurors. I mean, how can you, if you have multiple jurors coming forward days after a trial ends saying that, hey, we acquitted her, but we were rushed out of there so fast and we didn't get to tell you? I think you got to look into that. Just look into it. That's all they're asking. So I think, yeah, because otherwise, going straight to like civil liberty union, whatever, you're going to every possible whoever who can listen, and the outrage that's in Massachusetts right now, and all the people calling for people to be like Massachusetts State Police to be looked at, and Canton Police to be looked at, the chief of police, Helena Rafferty, let's get her out of there. There's a whole lot of people that Canton is starting to rebel against. Not just Canton, but people of Massachusetts are starting to rebel, and they're fed up. And I don't blame them one bit. If this was kind of place I lived in, I wouldn't want to be there anymore either. um, I wouldn't want to live under that. It seems quite oppressive. Hearing like buzzing or something. I don't know what's going on. Anyways, yeah. So I wouldn't want to live in such an oppressive type of place. Although, this is any town USA, and that's what's so scary about this. And the fact that they just keep coming at her and they won't, just drop the charges, buddy. Drop the charges. I don't understand why they put themselves out there for so much scrutiny, because that's what they did. They opened themselves up for the public backlash that they're getting. They're the ones that brought this to trial. Karen Reed's attorneys came at them as, really forcefully in their pretrial motions and things to try to get these charges dropped, um, get them to stop coming at her. And, there were many reasons to recuse Judge Canoni. There were reasons to recuse the DA's office, and everything got denied, all thanks to Canoni. So what does that tell you about her? I can't stand her. I think she's so crooked. I really think she had a big role in it. I mean, just look at the way she talked to the defense counsel. I don't like it. I hope there's someone looking into Bev too. I hope the FBI is watching her. But they are. They're watching. They know what's going on, they're seeing, and if you watch Sean McDonough, Sean of the Golf, or going through the motions, whatever you call him, um, he's very confident that the feds are watching and there will be indictments coming. So I'm crossing my fingers that he is right and those things come true. So let me know what is happening in your mind regarding the Karen Reed trial. What do you guys think? What do you guys think about this motion? What do you think about these jurors getting another opportunity to come in and be interviewed by both counsel or even the judge, or have a special judge do it even? I don't care. Somebody needs to inquire about what their verdicts were for counts 1 and 3. And that's all they need to do. All right, guys, thank you so much for watching. Have a good night, and I will see you guys in the next one. Thank you so much. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.